Thanks for staying with us. The new marriage amendment bill has been receiving mixed signals. The bill seeks to rationalise pieces of legislation dealing with marriage and ensure that all persons, regardless of race, sex, gender, sexual orientation, religion or cultural beliefs, are treated equally and with dignity. But Associate Professor at the Department of Private Law at the University of the Western Cape, Anthony Diala, says there are many thorny questions that still need to be answered by the bill, and he joins us virtually from Cape Town. Thank you so much for your time this afternoon, Anthony, and this really does seem like a rather vast and complex discussion that is much needed. Now, the Department of Home Affairs has invited public comment on the draft marriage bill of 2022. Before we get into what the gaps are, you believe, talk to us about why this draft marriage bill was needed, because by the looks of it, there are some major gaps that the marriage bill, as it had stood, had not answered as yet, and some gaps that needed to be filled.
Yeah, sure. Thank you very much for having me. The draft marriage bill was adopted primarily to bring together the fragmented pieces of legislation that govern marriages in South Africa. As we are all aware, Home Affairs was concerned with the problems of South Africans marrying foreigners, the problems of marriages under the Civil Unions Act, under the Recognition of Customary Marriages Act, and religious marriages, all being governed by separate legislation. So it felt that it would be wise to bring all these laws under one omnibus legislation to govern marriages in South Africa. So that's why we have this draft marriage bill.
And while you have lauded the innovation in trying to bring this bill up to speed and in line with South Africa's constitution, you do believe that there are some blind spots that have been left behind, and that this draft bill does not reflect what you call the changing social and economic conditions. Tell us what you mean by that.
Yeah, definitely. The bill leaves quite a lot of gaps that are worrying. Before I mention these gaps, we should note that the bill emerged primarily from the from the white paper on marriages of 2022. Now, there were recommendations in that white paper as made by the advisory committee that advised the South African Law Reform Commission. And one of those recommendations is to have a separate bill for intimate, permanent life partnerships, and yet another one for people who are in unmarried relationships that are of a long-term nature. So Parliament was advised to either draft a separate law to govern these relationships or to include them in this draft marriage bill. So apparently Parliament chose to discard those recommendations because they are not mentioned in the draft marriage bill, and there has been no word as to what will happen to those relationships. So that's the biggest omission in the draft bill, that it fails to regulate unmarried or intimate partnerships in South Africa. And we know that there are so many reasons for why these relationships need to be regulated. I can speak a little bit more about them later.
Yes, indeed. And that major gap that you've mentioned affects so many people, but for different reasons. Like in the piece that you wrote on theconversation.com, you speak about that there are various reasons why people are in intimate long-term relationships. But one of them is also depending on where they are in the lobola process. And you go in depth about what kind of impact this draft bill has on those who are in those processes and what long-ranging effect it could have.
Yes, indeed. Another key, well, not omission, but a key defect in the bill is the way it defines lobola. So bride wealth is something that we know is fundamental to marriages under African customary law. The way lobola is defined in the bill makes it seem as if it is only men that can negotiate and receive it. We know that realities, socioeconomic realities have changed to the extent that some women are heads of their families, either through widowhood or through other circumstances, maybe separation. Maybe they are not formally divorced, but they are the heads of their families. They are responsible for raising the bride alone. If we define lobola in such a way that excludes these women, it's problematic, and it does not reflect current socioeconomic circumstances.
You say that it appears that Home Affairs did not add life partnership to the bill because it is controversial. There are so many people who are in life partnerships right now in different parts of South African society that would say, what's controversial about it? In a legal sense, why would Home Affairs see it as controversial?
Yeah. Home Affairs would see it as controversial because it is difficult to draw the line between what constitutes a normal, or well, an ordinary relationship and what constitutes a life partnership. So if parties did not enter an agreement saying that they are in a committed life partnership, it will be difficult for you to prove that they are in a life partnership. But it gets more complicated in that the Constitutional Court at the end of 2021 already gave a decision recognizing that couples who are in life partnerships have the same rights as couples who are in a normal marriage relationship.
So where to from here on that specifically? Are there any international examples that we can follow on that? Is it an extra piece of paper that people can sign? Can they show that they've bought property together or even have signed a rental lease for a year or two together? Surely there must be some kind of way forward or precedence that's been set that can be used as an example to work towards.
Well, the thing about the law reforms that we are making with respect to marriages, traditional leadership, and other aspects of social life in South Africa is that we are copying the models from the West. By the Western nations, we mean Europe and America. So if we are, and this is what something that I address specifically in the bill, liberalism. Okay, when you are open to other people's opinions or ideas, then you can adopt laws that reflect those opinions and ideas. So how far should the bill go? Are we supposed to copy in total, copy, go all the whole way in copying the ways that these issues are treated in the West? Or should we try to preserve some of our cultural practices that do not discriminate or that do not infringe on human dignity? That's why I speak about a balancing act, that we need to be careful how we draft the bill. Make sure that while we recognize these intimate relationships, because this is a reality that must be recognized. So it's either that Parliament adopts a separate bill, separate legislation to govern life partnerships and unmarried intimate relationships, or it brings them under this draft marriage bill. So that's the solution that I envisage. Of course, others may disagree, but that's what I think should be.
No, absolutely, it really does. And then just finally, as we close off our conversation, Anthony, this is open to public comment. Do you hope that some of these changes could perhaps still make the cut?
Yeah, definitely. I'm hoping that we can stimulate debate. I'm hoping that people can react and, make submissions to Home Affairs to make sure that we get these issues sorted out, because they are very important. There's no point in adopting this law and then there's a constitutional challenge the next year. I'm striking down. It doesn't make sense. It's a waste of public resources. So it's better that we address them now.
Okay, we're going to leave it there. Fascinating discussion there. Thank you so much for your time. Associate Professor Anthony Diala, the Department of Private Law at the Western Cape University. He's also Director of the Centre for Legal Integration in Africa at the University of the Western Cape, popularly known as UWC.